Hello and welcome to Freedom Watch. I'm Judge Andrew Napolitano here, defending freedom, defending your natural rights, and defending your right to have a government that stays within the confines of the Constitution. The Takings Clause of the Fifth Amendment of the Constitution of the United States says that the government may take property for, quote, public use, so long as the owner receives just compensation. Thomas Jefferson argued that the government shouldn't be able to take any property for any reason against the will of the owner. Conversely, Alexander Hamilton believed that the government could take any land that the government wanted to, that its power to do so was absolute, and it wouldn't even have to pay for it. A compromise between the two resulted in the clause allowing private property, usually land, to be taken only under circumstances that it would be put to a public use. But recent court decisions, such as the infamous case from Connecticut, Kelo versus New London, have blown the door open to government taking property, not just for public use, but for whatever the government deems as a public benefit. The new definition means that your land goes not to parks or power lines or highways or hospitals or schools, but to private developers that the government likes. One such case in Auburn, New York, has the government beginning procedures of foreclosure in favor of a hotel conference center. One couple from China who owned a shop in the area said they never knew that there was a law in the United States that allowed the government to take their property for private commercial purposes. They thought that only happened in China. Another resident is defiantly attempting to resist the state theft by stating, quote, "I'm going to fight all the way to the end." Joining me now is Robert McNamara, staff attorney for the Institute for Justice. Robert, welcome to Freedom Watch.
Thanks very much for having me.
How voracious is the appetite for government? Usually it's local or state government here as opposed to federal. How voracious is the appetite of the government for private property so that it can own it and resell it to its favorite patrons?
The appetites of land-hungry developers and tax-hungry bureaucrats are literally bottomless. What we're seeing in Auburn is just the inevitable consequence of New York's complete contempt for property rights. The city of Auburn is using eminent domain to take perfectly fine small businesses, not to build a road, not to build a school, but literally just to hand them over to a private developer that the city government happens to like better. It's absolutely appalling.
A lot of us that have condemned the Kelo case, Robert, which sort of institutionalized what judges had been moving toward anyway, changing public use to public benefit, and actually had the goal by saying more tax dollars for the bureaucrats to spend is a public benefit. A lot of us that have monitored Kelo and its and the reaction to it in the legal community think that it might not be decided the same way. I think you probably agree with me, but your adversaries in the Auburn case don't, because they're following Kelo almost to a T. Condemn private property and then sell it to somebody who will put buildings on it that it will generate more local tax revenue, period. End of the story. That satisfies the requirements of the case.
And what you've seen in the wake of Kelo is a real backlash exactly along those lines. No state Supreme Court has relied on the Kelo decision to uphold the taking since the decision came down. Since Kelo came down, 43 different states have changed their laws to make it harder to do exactly this sort of eminent domain abuse for private gain. New York, although, is one of only seven states that's failed to do anything.
All right, so what will happen in Auburn as a practical matter? Will the town of Auburn get the property? Will the property that belongs to your clients eventually be raised? Will the conference center be built before this case gets to the Supreme Court of the United States to change Kelo? Will it then be too late? Even if they win, will your clients get nothing but raw property back where their homes and buildings once stood?
And I think your last question is probably the best question, which is, will this conference center get built? A lot of people don't know this, but actually the promised development in the Kelo case has amounted to exactly nothing. Where the homes once stood in New London, Connecticut, there's literally just brownfield. There are feral cats, and there are weeds, and there are birds. The city of New London has built nothing. And all too often, the promises in these eminent domain abuse cases come to exactly that. Nothing. Developers come into town, they snow local bureaucrats with promises of pie-in-the-sky dreams that they're going to build in the future, and they convince local bureaucrats to steal land from local productive small businesses and hand it right over to them. We see that time and time again.
We are looking on the screen as you speak, and now as I speak, of the Little Pink Cottage, which is the name of a book, by the way, about the Kelo case, and it is a picture of Ms. Kelo's home, in front of which is an actual tombstone, which is a memorial to the rights to private property. But the reason the Kelo case ended up with nothing being developed is because the developer changed his mind. The developer there was a corporation set up by the city, which was going to develop property for Pfizer, a huge, big pharma company, and Pfizer decided not to move there. Let's say the developer in Auburn decides to go through with this. When do you think the Supreme Court gets involved? Before or after the conference center is built? And might the court say, well, it's too late. The conference center is built. We're not going to make these people rip down a building they just constructed. That would be waste.
Well, that's an incredibly important point. That's actually something we at the Institute for Justice have litigated in another New York case called Brody v. Village of Portchester that establishes the importance of proving of having courts determine beforehand whether these takings are going to be allowed, that you can't just let the government take the property before the courts decide whether or not this is a constitutional use of eminent domain. And what actually happened to Bill Brody in Westchester County is we eventually proved that the taking of his property violated the Constitution, but we proved that after the Village of Portchester had already taken his property, knocked it down, and constructed a privately owned parking garage. And what ended up resulting there was just an abject apology from the Village of Portchester, and they named an actual street after Mr. Brody. There's now William Brody Plaza in Westchester, New York.
You mean you couldn't get the court? You couldn't get the court to order the town to raise what they had built and rebuild at its own expense what they had destroyed and redeed the property back to Mr. Brody?
Well, that's why it's so incredibly important in situations like this, where the government is coming in, planning to aggregate all of this land and just turn it over to a private developer who's making grandiose promises, that courts have to be involved at the outset, that the entire structure of our governmental system is that courts serve as the fundamental guardian of our individual rights. And the government can do nothing to you until a court has decided whether or not that is constitutional. That courts exist to prevent exactly this sort of disaster. That courts exist to prevent the city of Auburn from saying simply, we like this guy better than we like you, and so we're going to take your property. And that's exactly what courts should do in this situation in Auburn.
I know you're on the legal side of this, but on the political side, is there ever backlash against the politicians who decide to do this? I mean, or is this popular when politicians do it, except for the people whose property they're stealing?
It is unbelievably unpopular when local politicians or state politicians decide to use the power of government just to benefit a private party. And we've seen that in Auburn, where hundreds, literally hundreds of residents in this small town in upstate New York have rallied against the abuse of eminent domain. The ordinary American understands at a gut level that if someone else's property rights can be violated, that means your property rights can be violated. If the Jang's restaurant can be condemned to be handed over to a private developer, that means anyone's property can be condemned to hand over to a private developer. People really understand this at a visceral level, that if your neighbor's property rights aren't safe, your property rights aren't safe. And these projects are incredibly unpopular, and politicians are starting to recognize that. As I said, 43 states have changed their laws to make it harder to do exactly this, because people recognize that at a very fundamental level, it's morally wrong to steal. Any kindergartner can tell you that. Unfortunately, many bureaucrats cannot.
Robert McNamara, you are at the forefront of preserving us from the tyranny of the majority. Thanks very much. Come back and tell us how this case goes as it makes its way through the courts. Thanks for joining us on Freedom Watch.
Thanks very much for having me.